What about the technology side? So we have other trial attorneys on that, do really well with technologies and mediums to present to the jury. Is there anything in particular on the tech side that you like to use that you feel is a benefit?
Sure. I mean, we do a lot of medical malpractice, and even if it's not medical malpractice, a personal injury case involves medicine in some form. So I typically always have something to help the jury understand the granular details of injuries. I'm a firm believer that if you're talking about an injury, you're really going to get a lot out of it in terms of doing your discovery and then presenting a trial by getting as granular as you can. A comminuted fracture, what does that mean? Getting the doctor to say, well, that means there are literally shards of bone, things like that that allow the jury to better understand the details of the injury. So you have to present that, I think, technologically and give the jury a visual picture. So that's something that I always do. And then also, as it relates to, your exhibits, as it relates to all your witness examinations, open, close, you want to have a seamless presentation. And so I am very fortunate. I'm gonna give a shout out to Caesar Salinas at our office. He's our IT guy. We do it in-house. He's been at every trial that I've had, going all the way back to that downstate one. And he is unbelievable. And so, he and I are, we're like two peas in a pod at trial because we've got a rhythm, both in our preparation and in our execution. And so I'm very fortunate to have Caesar on the team. But at the same time, I don't like it to just be technology overload. I think you might see that sometimes with like big law firms that think they have to show off how many resources they have and show the jury how, how they come from, they wear the white shoes. But technology is good, no doubt about it. You got to use it. But I love flip charts. Especially if you're going to have a trial that lasts any length. If it's going to go 2-3 weeks or more, my most recent case was 6 weeks. I was terrified that the jury would forget about our evidence. And so what I love to do is have flip charts, which are easy. You got to think it through in advance, of course, and you got to have a solid plan as to how you're going to do it. But creating these flip charts that are living, breathing documents that the jury sees, it helps them remember it, so that the way it works is, with witness number one, they see you creating this flip chart. You're building this evidence. And then witness four, you add to it a little bit more, or you bring it back and show it to witness four. And then you show it again to witness seven, the defense expert, and that way they see it over and over again, and you're reinforcing that good evidence in a way that's very memorable. Because I'm always concerned that 6 weeks later, they're going to be like, we think our first witness is one of the most important ones, right? But then the jury's not even deliberating for 6 weeks. They got to remember the good stuff. So I love technology, but I don't want to overdo it. I love mixing in kind of the low-tech visual stuff. And then Caesar. Can't do it. I won't go to trial without Caesar.
Fantastic. And thank you for sharing that. And, we got to talk about the record-setting $363 million toxic torque jury verdict. Those are unnatural. Those are record-setting. What's different about this case? How do you get, first of all, as much detail as you can share or you would like to share on how do you land a case like that? Is it a referral? Are you sourcing it yourself? And then how do you extend the value and paint and create that story and that narrative to get to that extreme of a 9-figure type verdict? Tell me big picture just a little bit on that trial.
Sure. Sue Kamuta, the plaintiff, who is a hero in her own right, what she put herself through in the preparation for that trial and being kind of the lead plaintiff throughout. I mean, her name was the lead. She was the name of the litigation. It was Kamuta et al. Right, versus Sterigenics, and at the end of it, there were over 870 other plaintiffs behind her. So she was the first trial. Her discovery was first, and all that. She just came to our firm, word of mouth. came to our firm. So we were very fortunate that she did. And then we knew that she had a good case in terms of the distance, how far away from the facility that she lived. And so with that, she was filed first, understanding that the Circuit Court of Cook County may very well be putting that case first. That's sometimes how they do it. First filed is first tried. And so ultimately, we got to trial, and over the course of the 4 or so years between when we filed and when it went to trial, of course, significant discovery was done, but that discovery applied to all cases. And so it wasn't just, me and our team handling discovery on behalf of Sue. We did the plaintiff-specific stuff, but we had 7 firms that were part of the plaintiff's executive committee, and ultimately 2 of those firms I asked to co-counsel with us on the case. And so I led a trial team of 6 lawyers that actually ultimately presented witnesses, at least one witness in front of the jury, and really 9 or so lawyers in total in terms of what we had going on behind the scenes. And so, learning to lead not just your own team when it's your own firm, which is a little more natural, but also folks from other firms was very important. And that there was a steep learning curve for me. But I think it all came together in really a beautiful way, the way we kind of started out feeling out one another and figuring out how to work with each other to the end, where it was seamless and decisions were being made and agreed upon, and everybody was really rowing in the same direction. But then in terms of the development of the evidence, really, as we went through discovery, it became pretty evident that if presented the right way, we could really show some of the serious misdeeds of these defendant corporations. And we showed that at trial. Things going back to the early 80s when there were efforts to obfuscate some of the governmental investigations into the dangerousness of ethylene oxide. And then in addition to that, we learned that there were many pollution controls available to these folks. They knew it was a carcinogen, but they didn't put the pollution controls in. Meanwhile, while they're not spending, say, $500,000 in Willowbrook putting in pollution controls, over in Charlotte, for $5 million, they can open up a new plant. And why would they do that? Well, that type of capital investment is going to bring in revenue. Pollution controls is just a cost. That doesn't increase revenue. And so we showed those types of classic profit over people decisions that the corporation had made over the years. And I thought that was very effective. And then ultimately, I mean, at the end of the day, anybody that tries a case knows that you can have the best evidence in the world. You've got to communicate it in the right way. You've got to bring it through the witness, and frequently they are adverse witnesses. And you've got to bring it out of those witnesses in the right way, because a very nice sounding and smooth talking, credible person on the other side, even with terrible evidence, can totally put cold water on it. So you got to bring it out in the right way and make it hurt like it should, which is, to me, where the fun is as a trial lawyer. So I think the result showed that we did that. I think the jury ultimately, the $363 million verdict was in response to a $346 million ask. They went above what I had asked for in closing argument. And I think it's because they were mad.
Wow. I love a lot of things that you said about rowing in the same direction and being candid and saying, hey, I had to adjust here and be a leader, a different type of leader, and how you communicate that to during the trial to the jury to present this and the profit versus loss. And I wanted to kind of circle back to one of the things that you said earlier that kind of caught my attention on the marketing side, the biz dev side, was, hey, I'm using these flip charts because it's a way to be memorable, to call to an attention to a very important aspect of the case. Do you make that same tie-in to, say, your marketing on the business development side, like maybe the frequency of a radio spot or a TV spot or social media? Do you is the same mindset there? And talk to me a little bit about originating cases.
Sure. So I'm certainly a firm believer that if you uh, if you excel at trying cases, that everything kind of flows from there. If you're a great trial lawyer, and you can try cases with success, then that is going to drive settlement value in your other cases. That is going to bring referrals to you because people will see that this is the firm or this is the lawyer that is going to get the highest amount of damages for a particular injury or in a particular type of case. And so that's kind of old school mentality, and I firmly believe in it. And I want people to come to me not because I've wined and dined them and gone to Whites I See Your Blues.
Right.
At least it's not Cubs.
Your
Right?
your dad gave me head.
Yeah.
Hell, I had an Oakland A's hat on after St. Patty's Day, and he said I need to get rid of it, which was funny.
So I'd rather get the referral because the referral lawyer knows that we're going to do best for the client. But then, to your point, in this world, that's not quite enough. If people don't know about what you're doing, then it's not going to bring cases to your door. And so, first of all, I'll drop a few more names from our firm, but TJ Say and Marcy Mangan, they are unbelievable. Marcy's our PR person, and so I rely so heavily on her because on a daily basis, she's doing an incredible job of pumping out social media, publicizing our results whenever we can. Sometimes settlements have some confidentiality attached to them, but whenever we can, putting articles in the lay press or the Chicago Daily Law Bulletin, which is a very popular local legal publication, and getting information out there, and then being present in the legal community. I'm very active with the Illinois Trial Lawyers Association. I'm the current president. I still am for a couple more months until my term is up, and just being out there and developing those relationships in addition to people seeing your results. So we don't really do regular radio spots or TV spots in terms of advertisement. Marcy has some very good relationships with local news networks, so our lawyers are frequently on the news, whether we're talking about our cases or new laws being enacted or some legal question that's being asked. So I think we do a good job of being in the public sphere, both with just appearances that may not be attached to a result, but then also results so that people know that Salvi, Shostak, and
Yeah.
Pritchard are legit trial lawyers.